There is that 62 because it contains both. It does apply to pre-election stage. At every pre-election stage, whenever a nomination paper is to be challenged or an election is to be challenged, both theoretically would kick in. My Lord, if I may take a pause here. My Lord the Chief Justice.
Can we come back to Khakwani?
Yes, sir.
Khakwani is a 7-member bench.
That's right, sir.
Samila Baloch is a 5-member bench.
That's right, sir.
So, the 7-member bench judgment is not worth the paper it's written on. Either we respect the judges' judgments of the Supreme Court or we don't. Now here it says, number of hearings propose the determination of the following constitutional questions by a larger bench. It is a 7-member bench holding. How could a 5-member bench determine this matter then?
It was to be determined by a 7-member bench.
Isn't this binding on the 5-member bench? Is it not binding on the 5-member bench to answer A, B, C, D?
The 5-member bench.
Or it could be argued, that's another proposition, there are these questions which are incapable of an answer. I cannot answer these questions. Like Justice Asif Khosa has held. It's not a dissent, that's important. It's an additional note. So how can you just disregard one 7-member bench judgment, either attend to it head on? You can't just say, I ignore these 4 questions, I will decide it myself. You have to say something on Khakwani. You have to say these questions, you want to reframe, these are not properly framed, I don't know, whatever way. But how is a 7-member bench being disregarded by a 5-member bench which has specifically noticed these things? One learned judge had given a very categorical finding on it and have no discussion in the 5-member bench. So why should we not follow the 7-member bench as opposed to the 5-member bench?
That's
why is nobody insisting on Khakwani?
That's why, my Lord, my submission is that Khakwani, without addressing these, without actually acknowledging the existence or presence of this judgment, goes on to hold that it would be a court of civil jurisdiction, without addressing this question that why civil, why not? And in fact, Khakwani says declaration of conviction. So Khakwani perhaps implies that it could be both instances. Could be a civil declaration, it could be a conviction also, which would both be covered under 2-1F.
It just raises questions, valid questions.
Yes.
One judge gives an opinion.
That's right.
And says these cannot be decided.
Justiciable nahi hai.
No, but at least Samiullah does this, that it addresses the question as to what declaration it would be, and they said it's a declaration coming out of civil.
No. So that again, the Samiullah overlooks that the 7-member bench actually contemplated perhaps both. The 7-member bench said also part
to one extent, I mean, to civil only they've come up with some answer.
A part of A that they say that jahan pe court ka batana tha, to unhone kaha ki civil hoga. It did not then hold that why not a conviction.
And usme bhi problem ye hai, फिर तो अगर if we are so then we stuck on the very basic question कि declaration from a court of competent law क्या है?
That's right, sir.
So
that has to be answered.
So that's not answered.
Yes.
So बाकी सारी चीजें तो दूर की बात है ना कि duration
everything is based on that premise that there is a declaration by a court of law.
So we're assuming on Samiullah's argument that there is a declaration which would be between inter-parties arising out of civil jurisdiction, and then as a consequence we'll build into it that the person is not honest.
What would be the effect of that declaration?
And in effect we'll say
the consequence and so on.
I will go another way. I will say I cannot bring myself to disagree with Justice Khosa.
That was very profound.
What we have read. Can I not say that? I cannot bring myself to disagree with Justice Khosa.
Yes.
He's a 7-member bench member. The others have not disagreed with him. They should have said, we don't agree, this is a dissent you're writing. You're not writing an opinion of the court.
So where does that leave us, Samir?
So, my Lord, now I think as a first step, in my respectful submission, as a first step, my Lord would have to first hold what court would it be or what courts would it be, civil or criminal, either or both, which would give this sort of declaration for the purpose of 62(1)(f)(1). What would be the procedure which will have to be adopted for the purpose of that declaration? What is the standard of proof which would be required, both and then the locus standi?
In Khakwani, The High Court refused to interfere. High Court refused to interfere
Actually, this
for the reason that
question.
the High Court cannot go into such.
देखिए बात वहीं आ जाती है, इतने दिनों से हम ये सोच रहे हैं कि कैसे करें, तो आपके ख्याल में रिटर्निंग ऑफिसर समझ लेगा बात को या आम शहरी समझ लेगा?
मैं अभी आगे आता हूं।
जो खोसा साहब की बात है मुझे तो बड़ी भारी बात लग रही है, उसमें मुझे कोई आई एम ट्राइंग टू इन माय माइंड ट्राइंग टू disagree with it and I can't bring myself to disagree with it. He's saying you cannot give these declarations full stop. So maybe these are just rhetorical questions. They don't have an answer. I mean, there are many questions you don't have an answer for. This may be one of them.
इसकी एक interesting बात बताऊं.
However, nonetheless, Parliament has understood 62(1)(f) better than us and has formulated something. Okay, fine, good for you, Parliament. They represent the people of Pakistan. They've understood it, they've done it. Now, unless I can then say Parliament has done something wrong, the only thing Parliament says कि भाई आपके 7 member bench को हमने follow करते हुए ये काम कर दिया है. It is more in tune with the 7 member bench judgment, section 232(2) than Samula is.
That's right, sir. And मैं थोड़ा सा एक background बताऊं. My lord was originally अभी explain हुआ कि सिर्फ 3 provisions थी, A, B, C था 62 में. When the constitution was being made, certain amendments were proposed by members who belong to religious parties. I'm talking about the original constitution making, at the time of original constitution making. I just read out very slowly. I don't have, unfortunately, a copy of it. 2 amendments were proposed and the motions were made and they were negative. They were rejected. And if I may read out, they are quite akin to what was then inserted through revival of Constitution Order 1985 by General.
Where are you reading from? Parliamentary debates?
Parliamentary debates.
Copies दे दीजिएगा मैं.
जी copies दे दूंगा मैं. I'll just slowly read it out. And these were rejected.
What year is this?
This is, my lord, 1973. These are dated 15th of March 1973, sir. So the first amendment which was proposed was he is conversant with the affairs of the country, which is okay. He is conversant with the affairs of the country and is not reputed for his bad character or for contravening the injunctions of Islam. This was rejected by the House. Second, if a Muslim, he is honest, and not an open violator of the dogmas of Islam and possesses the necessary knowledge of his religion. Both were rejected. And while rejecting it, the speaker said, and I would just quickly read out one paragraph from the proponent of one of these amendments and then the response given by the speaker.
Who proposed these?
My lord, these were proposed by Maulana Abdul Haq of Akoda Khatak, Maulana Ghulam Ghaus Hazarvi and Maulana Mustafa Al-Azhari. So these were the 3 members who proposed them and the House rejected them. I just read out, these are very telling passages, what he had in mind and then how the speaker responded. And this is exactly what Justice Khosa has observed. जनाबे वाला मैंने तरमीम पेश की है कि पार्लियामेंट का जो रुकन हो उसका किरदार, उसका इखलाक, उसका तकवा, उसकी दयानतदारी, इसका मामला शनास होना, इस्लाम के बारे में उसकी बुरी शोहरत ना हो, ये खसूसियात भी लगाई जाएं. असल में इस दफ़ा में ज़ेली तौर से बहुत सी चीज़ें लगाई हैं कि अरकान में इनका होना ज़रूरी है. एहलियत होगी तो मैं अर्ज़ करूं कि ये जो है यानी जो पार्लियामेंट है, पार्लियामेंट जो है वो तमाम मुल्क में बहुत ही अहम इदारा है. इस ऐवान के अरकान हैं, ये आइन बनाने वाले हैं, कानून बनाने वाले और मुल्क के अंदर अदल व इंसाफ कायम करने वाले इदारे के अरकान हैं. इसका जवाब सर. Speaker responded and then obviously it was then later put to vote. He said, आप मुझे इसका जवाब दें कि आपने फतवा दे दिया कि इसकी शोहरत अच्छी है और वो अहल है. दूसरे कई उलमाए कराम ये फतवा देते हैं कि इसकी शोहरत अच्छी नहीं है. इसलिए ये चीज़ इसके मुंतखब करने वाले जो लोग हैं, जो वोटर हैं, उन पर छोड़ी जाती है. अगर वो समझें कि वो अहल है तो वो अहल हो सकता है. And then ultimately it was put to vote and was rejected. So जो
Maybe it's a guideline for the voter.
Yes.
Maybe, why can't it be considered a guideline for the voter? Maybe you want, it's maybe not on your radar, but you should consider these points.
Some sort of inspirational standards for future.
D, E, G, and precisely are that. Now, what happened here? Mr. Uzair Bhandari argued, and he relied on paragraph 33 of Samiullah, where Samiullah Baloch, with respect, erroneously relies on Imtiaz Lali case of 2007 to say that pre-18th Amendment, the Supreme Court had disqualified someone for life under 62(1)(f, erroneously. Paragraph 33 refers to Imtiaz Lali, which is PLD 2007, Supreme Court 369, which was incorrect. In Imtiaz Lali case, he was disqualified on the basis of a provision which was introduced in Representations of the People's Act through Conduct of General Elections Order, which was Chief Executive's Order number 7 of 2002, on the basis that a person who was dismissed from service on the basis of misconduct or moral turpitude, full stop. They applied this provision to hold that if he could not get back into service, he could not get back into the parliament either under 63. So this is what Imtiaz Lali did. Now, what did parliament do to respond? In 2010, parliament then placed timelines for G, H, I, J. Now, J deals with removal from service on the basis of misconduct. They said that if he's removed on the basis of misconduct, he could come back in after 3 years. And on moral turpitude, if he's convicted and after serving the term, he can come back after 5 years. So Parliament had this judgment in mind and responded to it. What Parliament did not have in mind was that while they were creating actually a safety valve under 62(1)(f, against any arbitrary decision by a returning officer, where the returning officer would ask someone XYZ, or somebody would come make an allegation against somebody that he is dishonest or he owed me something and he has cheated me, etc. Parliament pegged it with a declaration by court of law. And that declaration, now as I go in greater detail what that declaration would be, this is the safety valve which the Parliament had created, and unfortunately, from Ghafoor Lady to first Aladino Bhaio, the original Aladino Bhaio, to Samiullah Baloch, this court then actually turned into something which constitution makers never contemplated. Nowhere in 62 or 63 has anything been made perpetual disqualification.
But before we even get to the time frame, what I'm understanding from you is that we haven't yet crossed the first hurdle as to what kind of a declaration this is. Because under the current dispensation or legal framework, no such declaration can come about. Samiullah goes ahead and crafts a declaration, says that in case there is some civil litigation which comes up with something, then we'll, as a consequence and as an effect, connect it and make him dishonest or a mean. So there is no direct mechanism or procedure available in the current legal framework to achieve such a declaration. So having said that, one option could be that the Parliament goes ahead and decides the procedure, or there is a constitutional amendment, whatever might be the case. How could a court of law like us resolve this issue? Because under the current legal framework, such a declaration cannot be given. So what happens if there's a constitutional provision which becomes practically unworkable under the legal system? What do we do with that provision?
My Lord, my respectful submission is, and I attend to my Lord's question, but if I may just first submit, that such declaration, now if we look at the courts of civil jurisdiction and see its declaration is given by a civil court, this sort of becomes a bit inconceivable, because in what situation would that declaration come out? No. But if this declaration in the form of a conviction is given by a criminal court, then there are several instances where such conviction regarding the character, which is the honesty or dishonesty of a person, could be given by criminal courts and the penal code. As I just gave an example of section 403 of penal code, a person who dishonestly misappropriates somebody's property, upon conviction he is punished. Punishment is up to 2 years. 63(1)(h) is threshold, doesn't get triggered, because that is more than 2 years. So remaining under 3 years, under 2 years, there is a declaration of him having dishonestly misappropriating property.
It's not the civil declaration that's the problem. Right?
Civil declaration is a problem. Now, similarly, cheating, for example, is being deceitful, which is dishonesty.
Sure.
So again, it's 1 year. So वहाँ पे शायद आ सकता है, वहाँ पे शायद आ सकता है criminal proceeding. But civil declaration, as my lord has just observed, I can't think of anything.
So then, what is the answer?
Now, my lord,
is the first question that since Ishaq Haqqani is pending, right?
Ji.
So unless we cross this hurdle, building a time frame and all that is a secondary question.
so that is one. That is one. It is all.
So it is best either you leave it to the parliament to do a constitutional amendment or do whatever they want to come up with.
For that, you don't need a constitutional amendment. Now, this is my second submission.
नहीं, मुझे एक चीज बताएं, ये हम फंस गए समीउल्लाह बलोच में, मगर जब ये खाकवानी का आपने जिक्र किया, मैंने अभी पूरा जजमेंट देख रहा हूँ समीउल्लाह बलोच का, ये कोई बहुत पुराना जजमेंट तो नहीं है, नेचुरली रेडार पे होगा, दुनिया भर के वकील इसमें पेश हुए, किसी एक ने जिक्र नहीं किया खाकवानी का। I find that very difficult, और उसमें जो सवाल उठाए गए थे तो मतलब उसको नजरअंदाज कर दें, हम दूसरी तरफ चलते हैं, मतलब मुझे कुछ गैर मुनासिब लग रहा है।
These questions had to be addressed.
एड्रेस नहीं, कोई पुराना कोई नहीं, कोई 10 रिपोर्टेड जजमेंट है, PLD में लिखा हुआ है उसको, तो वो पूरे जजमेंट में उसका तस्करा ही नहीं, और हम फंसे हुए समीउल्लाह बलोच में, हम खाकवानी पे क्यों ना जाएं?
बिल्कुल जाना पड़ेगा, और जाना पड़ेगा, जरूरी है।
नहीं मगर नहीं, आप देखिए जो चीज हमें नहीं समझ आती है, अब सपोज एक मैं नया टर्म इस्तेमाल कर देता हूं, मैं कल को आइन बदल देता हूं, उसमें लिख देता हूं पार्लियामेंटेरियंस मस्ट बी इंटेलिजेंट, ठीक है, फेयर इनफ, कौन डिटरमिन करेगा? कोर्ट ऑफ लॉ करेगी? कर ही नहीं सकती है। मैं ये आपको कह रहा हूं, मेरे हिसाब से ये कोई चीज भी कोई कोर्ट नहीं डिटरमिन कर सकती, बिकॉज ये उनके जुमरे में आता ही नहीं है। कोर्ट डील विद नॉट फिलोसॉफिकल कॉन्सेप्ट्स, कोर्ट डील विद टेंजिबल थिंग्स। हाउ कैन यू डिटरमिन समवन्स ऑनेस्टी? एंड इट्स अ वेरिएबल, अ पर्सन मे बी ऑनेस्ट टुडे, डिसऑनेस्ट टुमारो, ऑनेस्ट टुडे, डिसऑनेस्ट टुमारो, आई डोंट नो, पीपल कीप चेंजिंग. So these are not the kind of determinative things. Probably the 18th Amendment brought in the word through a court of law to virtually kill it off, but they didn't realize they probably created more of a mess than the original wording. I don't know, that maybe have been the intent. अब पार्लियामेंट ने काम कर लिया है, मुझे नहीं समझ आया, अगर उन्हें कर लिया है चलें, गुड लक टू देम, उन्हें का 5 साल, फाइन, why can't we live with it? I mean, जब 7 मेंबर जजेस कह रहे हैं कि ये सवाल या तो इनको अटेंड करें, आप इग्नोर नहीं कर सकते हैं कि जी आप मैं दूसरा जजमेंट लिख दूं, मैं उसको इग्नोर कर लूं, जब बिल्कुल वही चीजें हैं, वही इशू है, वही इलेक्शंस की बातें आ रही हैं और आप उस तरफ चल पड़े। सॉरी, मेरे हिसाब से आई एम रीडिंग मोर एंड मोर ऑफ जस्टिस कोसा's जजमेंट एंड आई फाइंड दैट द आंसर, यू कैन नॉट answer these questions. Not every question is answered. Some are answered in the hereafter. Some are answered, okay, if I take a vote today, no disrespect to you, is Mansoor Awan an intelligent person? Maybe some will say no, most will say yes, I can assume. So these are opinions. I mean, you may hold a thing on myself, they'll have an opinion on me, but it's not something that I can get a declaration from a court of law. Declaration of court of law means that you cannot have a second opinion on the matter. End. Khatam.
No, but having said that, the legislation that's come about is also ignored Ishaq Haqqani, because where is the answer to what kind of a declaration should it be? It just answers the time frame. That's a secondary question. The legislation should have thought that there's a Ishaq Haqqani raising all these questions. They should have explained where do we get such a declaration? How do we do it? What's the procedure as it mentions? But all these things are missing. So, I mean, we can't even get to the second question if we want to take it head on, unless we can come up with some sort of a sandwich definition of a
जवाब में मैं ये कह सकता हूँ, कल शायद पार्लियामेंट करने दें उनको अपना काम.
Fair enough. So I'm just saying that even if we were not to address this head on and come up with some sort of a sandwiched answer to a declaratory order or whatever, a declaration, it will lead to problems for the future again.
Now, at the end of the day, we have to establish one thing once and for all. Do you believe not just in election, election कराना ही तो एक process है. Process से तो आपको कुछ मिलता नहीं है. Democracy means that the will of the people is reflected. The will of the people, whether they bring a constitutional amendment, whether they bring a legislative thing, it is the will of the people, whichever way you look at it. The next lot of parliamentarians will come, they will make a law saying this will be a lifetime ban, then we can consider its constitutionality. Our role should only be not to fill in the constitutional gaps, if there are any. Our role should only be to examine legislation, does it accord with the Constitution? And I would go back, I may not even agree with Parliament, but I will keep quiet about it. Yeah. As a voter, I may do something else. So why are we getting bogged down in this business? Why are we doing this job?
So if I may just address both of these questions, observations and questions. The declaration under 62(1)(f) has to be by a court of law, acting under a law or several laws. The law has to provide for which court will have to give that declaration, and then of course the entire process, including who will have the locus standi and the standard of proof which would be required for such declarations. Now what section 232 does is, and stops midway, is that it says that the procedure, manner and duration of qualification and disqualifications will be such as is provided under 62 and 63, and where there is no procedure, manner provided, it will be such as is provided.
The legislature is actually not addressing that.
Now this declaration question has been left open.
It is not the answer of
not been addressed.
It's not addressing the question.
It is not. Now what it does is, it says that whenever that declaration comes out, the effect of that declaration would be for 5 years.
That's it.
That's the only thing it does.
How that will come out?
Yes.
Will come out.
So
I wish the wording was that the declaration is for that period.
Yeah,
it doesn't say that, but that's a separate issue. But I think that's a secondary issue. The main issue is, what do we do? I mean, we can't even say that this legislation has come up with an answer either.
So declaration subject to due process of law, ye likha hua hai.
Due process of law, and then it says that the disqualification shall not exceed 5 years from the date of declaration.
I'll tell you what Parliament did.
Parliament has.
उन्होंने कहा हम इसको बस छोड़ो, इस बहस में पढ़ो नहीं, 5 साल कर दो, खत्म. That's in a nutshell what Parliament did. We can't tell Parliament to craft a law this way, because in my mind this is the best way to proceed. This is their job. Our job is another job. Is it unconstitutional? My lord, one proposition was put forward: do not touch upon 232. You may need to touch upon 232 at another juncture. I'm just speaking aloud for myself, I tend to agree with that. Nobody has challenged it. We assume it's okay till someone comes and attacks it. Maybe it's a very good attack. I don't know. Maybe they say, "Ki 5 saal bhi kyun?" I don't know. Let's leave all these things. The fact is, someone has applied their mind and made a law, and that law specifically mentions all judgments of any courts. So that law has shown us respect, in the sense that they have just, like my Honorable Justice Afridi has said, for the not lifetime thing. So they've kind of brought it about by this legislation 5 years over. अब ये बहस किसी और दिन के लिए रखेंगे हम, अगर जरूरत पड़ेगी या नहीं.
ये ठीक है. And then also this important question.
What do we say about declaration?
Now it seems that at the time of Samiullah, the court was pushed to do the work of the parliament, and now again it is being presumed that we will do the work of the parliament.
And court has not said for the permanent disqualification, it is only as long as the declaration will remain in field. Again, I will put you this question: why the section 232 cannot fix the period of that declaration?
It can, sir. Because, and I respond.
Then there is no inconsistency between the Samiullah and the Act.
Because 62(1)(f) has two components. One is this cause of this disqualification. This cause of this disqualification, and cause of disqualification is a declaration by court of law. So this declaration or this cause is rooted in law, resulting in a declaration by a court of law, and the consequence is constitutional, which is a person stands disqualified. Now, what the Parliament has done is it has limited and placed a certain limitation upon the cause, the declaration. The consequence stays where it is. Now, the
declaration means the disqualification will remain in field for 5 years.
In this case, 5 years.
Section 232.
Yes. Yes. And if, for example, if there was no 232(2) and Samiullah is overturned, then the disqualification would only be for that election. For that particular election, which is declared either void or a person is de-seated based on that declaration. He would become eligible after if Samiullah is overturned. But this law then places a certain limitation. It gives longevity to that declaration of 5 years, which, to my mind, my lord, Parliament in its wisdom thought that if under 63(1)H we had provided 5 years at that time, then because this declaration is coming under a law and for that constitutional amendment is not required, it is only perhaps fair that we give a cooling off period of 5 years.
So what is the procedure to deal disqualification under section 60, under Article 63?
Sir, now when a declaration is come and if the question arises a person has become disqualified, then chairman or the speaker under clause 2, the question goes to them and then they refer to election commission.
Under sub-article 2 and sub-article 3
that's right, sir.
Article
that's
63.
Right. That's right.
Mr. G, Article 62 1F says court of law. Whether criminal court is not court of law, and
yes.
why in Samiullah Baloch it was restricted only to civil court.
जी जी नहीं हो सकता मेरा ख्याल है अब पार्लियामेंट उसका क्या फैसला करती है वो पार्लियामेंट ने उसका एड्रेस करना होगा बट और अनलेस माय लॉर्ड्स आर माइंडेड टू होल्ड बट इन माय रिस्पेक्टफुल सबमिशन इट कुड बी बोथ इट कुड बी अ declaration by a civil court or a conviction by a criminal court which might entail these consequences but that is again
it is assumed if it is of the opinion that member has become disqualified. अगर ये
these are again safety valves, my lord.
No, safety valve तो है. इसका मतलब है कि अगर कोई declaration हो, despite that declaration, the election commission can undo that declaration.
No, the election commission, for example, the election commission, for example, disregards that declaration.
Yes.
Then a person can come before your lordships or in the High Court under 199 Covenanto and say that here is a declaration.
The validity of the declaration issued by court of law.
Yes. So declaration is not the validity which can be questioned by the election commission or by the speaker or a chairman in that case if they come to the conclusion that this declaration is actually not 62(1)F declaration. This is perhaps for an offence or something which is not covered.
Mr. Mansoor, you've landed us in a bit of a more problem here. So the question was earlier that we were going along with whatever semblance of a declaration was given by Samiullah or civil litigation, original civil litigation. We thought we'll take that declaration and then play around with the duration period. Here the question is that there is no declaration and that's not really a declaration, and Isaha Kwani raises that question. Nobody has addressed it head on as to what could be such a declaration, and that declaration probably requires some serious thought from the Parliament. So where does that leave us now?
So my lord, what that leaves to your leaves you, the declaration so far given, people might come in due course to the courts that these declarations were not declarations by a court of law. I dare not.
I put myself in the position of whatever that court is for the time being. I would say I cannot give this declaration. Bye. Take away your suit. Take away your plane. Take away whatever you want to do. I cannot do this. I mean, I cannot go into your hearts and determine what sort of human being you are.
That's right.
So taking that question further, what do we do with the constitutional provision now?
So what happened here?
Say it's unworkable. Wait till the Parliament decides.
My friend,
इसका भी जवाब आसान जवाब है, बहुत आसान जवाब है. इसका बहुत आसान जवाब है. जो लोग कॉन्स्टिट्यूशन बनाने के माहिरीन थे, उनमें ज्यादा अकल और दानिश थी. उन्होंने 73 का आइन बना दिया
और उन्होंने ये
एक साहब टहलते हुए आए, उन्होंने कहा हो कहीं ये लोग सर ना खड़ा कर लें तो ऐसी चीजें डाल दो इसमें कि हर कोई जो मेरी मर्जी हो मैं उसको डिस्क्वालीफाई कर सकूं। अभी इस बात को हम क्यों नहीं कह रहे हैं, इसको बात का एतराफ क्यों नहीं कर रहे हैं? समीउल्लाह बलोच स्पेसिफिकली मेंशंस दैट इट वाज इनकॉर्पोरेटेड बाय इन द ड्यूरिंग मिलिट्री टेकओवर।
बिल्कुल बिल्कुल।
So I mean
the revival of
I don't know why we so
1985, but 18th
we go
amendment
into
में Parliament had the
niceties of
opportunity,
grammar and English and we are forgetting the overall picture.
18th amendment. The problem is that
18th amendment भी वही मसला है ना कि इधर आपने देख लिया क्या हालत हुई थी पाकिस्तान में, वो भी हम क्यों नहीं बात कर रहे हैं उस बात की? जरा सी उन्होंने लैंग्वेज बदल दी तो उन्होंने पता नहीं पूरा पाकिस्तान came to stand still. We must realize that there are issues which are exploited for personal ulterior motives.
my lord,
Gain certain political advantages. ठीक है? Now, once we are not a court of law that we should shy, we are not that we should shy away. We are a court of law, upholding the Constitution of Pakistan. Constitution does not, rightly or wrongly, does not provide a time period. Why should I fill in what the Constitution has intentionally left, even if I accept it at par with every other constitutional provision, something brought in by a military dictator? भाई उन्होंने नहीं किया, वो जाने, मैं क्यों काम उनका करूं? नहीं, आपको जरूरी करना है, क्यों? भाई देखें, absence is also a decision. If I don't decide to do something, I'm deciding something. Parliament has elected to remain, leave it aside. We also leave it aside.
my lord,
अगर वो कल कोई कानून साजी करेंगे हम देख लेंगे उसको।
Mubashir Hassan case में my friend Ahmed Qayyum read out paragraph 115 from Mubashir Hassan, where the full court held that 62 is not a self-executory provision. 62(1)(f) is not a self-executory provision.
वो कितने judges थे?
जी, sir, it was a full court. It was, I believe, 15 or 17. Full court थी, sir.
What context was that?
So they were looking at examining 62(1)(f) because it was NRO which was under challenge. NRO under challenge था, तो उसको वो देख रहे थे, and उसमें 62 को उन्होंने examine किया 62(1)(f) को, and they went on to hold that it is not a self-executory provision, and by that, I think it doesn't explain it in that detail, but perhaps the rationale behind that was that because there is a declaration by a court of law which is required, then there is a law or several laws must also provide some mechanism how that declaration is to then come out.
I mean,
now, what has happened here is that 232(2) provides a time frame for the longevity of that declaration, but it does not then address the 4 questions which were left open by.
I mean, this constitutional silence has really got us.
नहीं sir, अब आप उसका ये कर सकते हैं. Options here. Either you leave it to the parliament.
Yeah.
Elections are around the corner. Leave it to the parliament.
Till then, what is the status of this provision?
So this provision is, as the Supreme Court held, is not a self-executory provision. It requires making a law. The law has to be made. And that is for the parliament to do.
नहीं, अगर ये इन्होंने wording लिखी है specifically, मैं मुबशिर हसन देख रहा हूँ. मुबशिर हसन में जरा गिनते हैं 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 17.
Paragraph 115.
हाँ, 115 में 17 जजेस हैं, यानी कि full court. It is true that अच्छा. The provisions of Article 62 of the Constitution cannot be pressed into service because it is a provision of Constitution which is not self-executory. तो ये तो फिर बुनियादी उड़ा देता है बाकी जजमेंट्स की. इससे अगर मैं डिसएग्री करना चाहूँ मैं कर ही नहीं सकता हूँ, क्योंकि अगर हम सारे जजेस भी बैठ जाएं फिर भी हम 17 नहीं बनेंगे.
Did Ishaq Haqqani look at this?
Ishaq Haqqani did not, I think.
Ishaq Haqqani probably realized.
Ishaq Haqqani was perhaps
अच्छे सवाल हैं मगर इनका जवाब नहीं मिल सकता.
But Ishaq Haqqani would have, if it had gone on to examine it, I think this question would have come. Or that because this provision actually requires making of a law by the parliament to give effect to this.
There is a reference to a judgment, Muhammad Afzal versus...
Yes, is Raja Muhammad Afzal versus Muhammad Altaf Hussain. 1986, 1736, it said that...
Finding to
that judgment said that it's a declaration.
think this has clarified something.
Mubashir Hassan sort of puts an end to it.
Is a definite finding.
It's an inert, innate provision.
Yeah. So as D, E and G, for example, now they operate on their own, perhaps more so an appeal to the electorate.
Yeah, then they
F also is an appeal to the
after
electorate.
this finding, they just join the family of the rest. You see, D, E, and G. They all become nice inspirational guidelines that we must have a parliament like this. And that's it.
That's it. And if we have an appropriate law providing for how that declaration would have to come forth, it is
In a way, which is any judgment.
Yes. But what Mubashir Hassan, what 232.2 does is, it does provide for the duration part. It does not provide for the procedure and manner part.
In Samila Baruch, Mubashir Hassan was mentioned or no?
No, I don't imagine, sir. I did not come across more.
कि मुबशिर हसन में कहा है कि विच इज नॉट सेल्फ एग्जीक्यूटरी, ठीक है, बट अब समीउल्लाह में अगर हम देखते हैं, समीउल्लाह में उन्होंने कहा कि सिविल कोर्ट का जजमेंट होना चाहिए, तो उन्होंने भी सेल्फ एग्जीक्यूटरी तो नहीं कहा है, उन्होंने भी कहा है कि जजमेंट होना चाहिए सिविल कोर्ट का. देयर मस्ट बी सम डिक्लेरेशन बाय द सिविल कोर्ट.
ये उन्होंने कहा, और ये उन्होंने जरूर कहा, और ये अल्ताफ ये उन्होंने जरूर कहा कि जी डिक्लेरेशन होना चाहिए. एंड परहैप्स ये
नहीं पर आप ये पढ़े ना, जरा वापस आइए,
एक रीडिंग
114 पे आए, पैराग्राफ पेज 423 ऑफ मुबशिर.
जी, उसकी एक रीडिंग ये हो सकती है.
नहीं, वो पढ़ेगा, इट इज ट्रू, जरा देखें उसमें, तो फिर आगे वो कह रहे हैं पैराग्राफ 114 का लास्ट जो है, इट इज नॉट that self-execution.
It is true that section, it's Article 62(1)(f) of the Constitution cannot be considered self-executory.
Again, is relevant.
But if a person involved in corruption and corrupt practices has been finally adjudged to be so, then on the basis of such final judgment, his candidature on the touchstone of 62(1)(f) of the Constitution can be adjudged to the effect whether he is sagacious, righteous, non-profligate.
So how is it to be judged? तो उन्होंने भी नहीं छोड़ा.
Two steps. उन्होंने भी लिमिट कर दिया where a person is involved in corrupt practices.
It actually perhaps goes a step further to say that एक आपके खिलाफ conviction आ गई कि आपने चीटिंग की है 415 की, तो उन्होंने कहा कि उसके बाद जब वो आ जाएगी तो फिर देखेंगे कि आप फिर डिसऑनेस्ट थे, फिर भी थे कि नहीं थे. So,
in corruption and corrupt practices तो ये नैप का रेफरेंस है. नैप का रेफरेंस.
जी, वो तो नैप का था.
Dr. Mubashir's case will not be 14th and 16th of December 2009.
That's right.
Whereas the 18th Amendment
declaration by court of law came later.
तो इसलिए ये
उस हद तक नहीं,
उस हद तक ये आप उस पे रिलायंस नहीं कर सकते.
वो ठीक है सर बात, but what it does say is, it does the part of paragraph.
क्योंकि देखिए लेजिस्लेचर
जी ठीक है,
टाइम नहीं था दिया हुआ.
जी ठीक है. के ऊपर, where the court holds that if there is some finding of corruption or corrupt practices, because it was examining it in that context, comes out and a person is convicted, then he will again have to be adjudged. That's right, sir. So, वो जो declaration by court of law की जो insertion है, that insertion actually
initially the little hope that you built has disappeared.
तो गुंजाइश छोड़िए कि जी corrupt practices में involved भी हो, उसके खिलाफ judgment भी हो जाए, फिर भी वो adjudicate दोबारा किया.
वो adjudicate, that's what it says. And then 62(1)(f) also perhaps goes on to hold as much.
On a lighter note, if you permit, Attorney General, in the morning on the reference I had quoted Winston Churchill, and probably Winston Churchill can again be quoted on a riddle wrapped in a mystery inside an enigma. So I don't know, maybe that is appropriate. And I just wanted to mention, there may be questions why all the judges are not here during the reference. A judge has had surgery, eye surgery, another is indisposed, 2 out of the country, and 2 on holiday. So everyone else present here was at the reference.
My lord.
So maybe Churchill comes to our rescue.
My lord.
It's a riddle wrapped in a mystery inside an enigma.
My lord, the situation now, you had 2 questions before yourself in the first order, which my lord.
वो तो 3 member bench का था.
पहला ही सवाल से
नहीं हम वही ना, मैं आपके सामने तो ये था कि समीउल्लाह बलोच और 232 में से क्या चीज चलनी है. I think no one across the aisle has seriously disputed or has seriously, other than Mr. Bidari perhaps, has defended Samiullah Baloch. Because Samiullah Baloch does not
serious
answer.
problems with it. He also said there are serious deficiencies. I think that's the word he used.
And in my respectful submission, there are actually very acute, serious problems with it, because it does not provide answers to the questions which go to the very root of what can happen under 62(1).
Because, I mean, we are all relying on Samiullah Baloch thinking that primarily it decides that once a disqualification takes place, it goes for life.
Yeah.
The more important aspect of it is, where is that declaration first coming from? And what is that declaration which Ishaq Haqqani says, please understand that. So they're assuming, not assuming that they've written it. They said that it's coming out of original jurisdiction, civil original jurisdiction. Is that the correct answer? Is something that we need to understand. Because it stops there, then forget about the period.
And also one more aspect, because Samiullah assumes that it would be a civil declaration. It disregards what Ishaq Haqqani had just noted, and it also disregards Justice Ijaz Afzal Khan's majority opinion in Panama 1, 2017, Supreme Court 265, where when he said what would be the court of plenary jurisdiction, he said it could be both civil or courts dealing with both
If it's a
civil
criminal conviction, then it has to be automatically taken care of in 63, you see, so it has to be civil. Because if there is a conviction, automatically it gets sorted in 63.
No, but 63 then...
You don't have to really think about 62.
No, all convictions are not covered.
Yes, my lord,
all convictions are not covered.
As for example, I said cheating punishment is 1 year. Now 63(1)H doesn't cater to it, but it could be covered under 62(1)F. And there could be other instances also, dishonest misappropriation of property, 2 years. So 363(1)H doesn't get triggered, but 62(1)F could.
If it's criminal act, then for that purpose, complainant has to be considered. Who will be the complainant? If it is during the election process, then of course the election commission can submit a complaint before a court. Wherefrom, if order is passed against a person, conviction is ordered, then it will again be placed before the RO that the person so and so is disqualified.
For example, under the Election Act, there are several offences. Corrupt practices ke hain, illegal practices ke hain. Personation is one of the offences, which is deceitful, being deceitful and dishonest.
इसको तो corrupt practices में मुबशरतन में declare कर दिया कि this corrupt practices इसको उस ज़मरे में लेके आए.
वो हो सकता है ना सर. उसमें जैसे आप अभी जैसे my lord has के पास है. If the parliament is to answer.
So the question precisely is that we want to, I mean, so far the way it's coming out is that it's unworkable. In the current legal framework, no such declaration can come about. So this is unworkable. Now, what is the theory, what's the doctrine if you see a provision which you set out to interpret is unworkable and can only be fixed through parliamentary intervention. What do we do with that provision? What do you call that provision? What happens?
I wouldn't say that it is unworkable. I would say that this provision required a legislative, a sub-constitutional
as it stands, it's unworkable unless there is legislative intervention.
In that context, yes.
So till then, what happens? What's the answer?
My Lord, I think my Lords may just refer it to the Parliament with their observations that this is what is required to be done. Now, and I'd say, I mean, one would think that this should have been done in 2010 itself when the Constitution, this amendment was brought in. But then perhaps, the consequences which this provision started producing was something which perhaps the Parliament at that time did not contemplate. Or after Ghafoor Lairy's first declaration, which said that it would be, the declaration would not go away with a flux of time, and then Samiullah saying this, Ishaq Haqqani was leaving it completely open.
With that background.
So
no, but we could just refer it to the Parliament with a lighter note as a footnote that please avoid constitutional silences in future because it creates a lot of problems for the court.
It does. Otherwise, and
Mr. Mansoor, sometimes it's better not to overthink things. And there's a great example from our Islamic history. Ar-Razi was a great jurist.
That's right.
And he was going, and a number of followers were following him. So there was an old woman who said, "Who is this man?" He said, "Don't you know him?" He says, "No." He says he's given 72 proofs of the existence. Ar-Razi overhears him. Her.
Seven-member bench was hearing these proceedings as we are in 2024.
Incidentally, 7 members.
Incidentally, this question would have long been answered.
So as long as this cannot be answered, and perhaps the Parliament will have to look at it. Till then, F is as good as D, E, and G, and they're all inspirational guidelines, and they will stay in the Constitution the way it is till such time the workability is provided by the Parliament.
That's right, sir. For now, 32(2) only provides the duration. It just leaves the procedure and manner open, and doesn't provide it.
Not commenting on the
without
32 because we might have different.
And Samiullah has to be overruled.
And the Parliament is at liberty even to restore the original Constitution.
I wish. I would hope so. About time we did.
We must hope.
About time we did.
Hey, I don't know. That's up to them. We won't tell them what to do.
I mean, it's a wish. As the law officer,
Chale, are you done?
My Lord, I think beyond this,
thanks for the bombshell at the end, and you sort of create
but I think this will then resolve at least the issue before your lordships in a manner where my submission, and I support all the submissions made with regards to Samiullah being overturned, but it should be overruled. It does not it failed to answer the question which was raised by Ishaq Haqqani. It does not even discuss them, and also Samiullah amounts to reading something into the Constitution which the Constitution did not contemplate. It is a court of law which had to function under a law, jurisdiction conferred upon it under a law, rooted in law. It is only the consequence which flows out of that declaration which is provided in 62(1)(f). Under section 32, subsection 2, Parliament has not tinkered with the consequence at all. Parliament has only provided a duration for that declaration. And so, my Lord, I think that way, at least there would be guideline for the existing process of election which is underway, but also I think the future Parliament would know what they have to do.
Thank you. I presume Advocate Generals don't need to add anything. Ajay, क्या कह रहे हैं? Sorry, you are from which province?
Advocate General Punjab.
जी.
My Lord, I've submitted CMA number 22 of 24, my Lord.
It's law.
That's on record, my Lord.
CMA number?
It's 22 of 2024.
G.
And my Lord, for
CMA is simply a concise statement.
I don't know what I've done is today, I've just made this skeleton of 3 pages.
Argument.
Lordships.
Take.
My Lord. Yeah. Considering all the arguments which have already been dealt with, my Lord, and something which is now left, my Lord. These are now the 3 pages skeleton, my Lord.
Good.
These can.
Brevity is the soul of wit.
Precious.
जी. Which सूबा?
खैबर पख्तूनख्वा, my lord.
आपने भी CMA फाइल की है?
जनाब,
कौन सी?
CMA number 40 of 2024 in civil appeal number 981.
आपने भी skeleton arguments दिए हैं?
Skeleton arguments with case law and especially vis-a-vis.
Excellent.
Very gracious. Thank you.
बलूचिस्तान आप अडॉप्ट कर रहे हैं?
मैं अडॉप्ट कर रहा हूँ सर, जजमेंट्स दे दो
For 5.
अच्छा।
और ऑलरेडी दी हुई है।
ये सारा मसला तो बलूचिस्तान से उठा है, समीउल्लाह बलूचिस्तान से है।
समीउल्लाह
आपको तो हल करना थे सारे मसले। वो कहाँ गए समीउल्लाह के भाई?
हाँ, वो कहाँ गए? उन्होंने तो उनको इजाजत दी थी कि वकील भी कर सकते हैं आज। अच्छा, बाकी कौन सा सूबा रह गया? सिंध not represented.
My lord, AG ICT was here. He had to leave. He was feeling very sick, but he said, "I will be adopting the Attorney General."
I hope you were not the cause of it.
No, my lord.
Not due to the case itself.
But no, not for the case, my lord. But he said he will be adopting the Attorney General's argument.
So let me thank.
My lord, few minutes on behalf of PTI अगर आप मुझे इजाजत दें।
अच्छा, हम तो बड़े देर से मुंतजिर से कोई सियासी पार्टी तो आए हमारे सामने।
सर, इसलिए हम हाजिर हो गए।
नहीं, बड़ी अच्छी बात है। It's always nice to see a smiling face.
Thank you, sir.
क्या कहते हैं, बड़ी देर कर दी मेरे बात।
नहीं सर, देर अभी नहीं हुई, हम तो पहले ही बहुत देर में हैं।
जी, जल्दी में।
जी, आपने कुछ फाइल किया है?
My lord, जी हमारा जो मेरा
कुछ फाइल किया आपने?
नहीं सर, मैंने कुछ भी फाइल नहीं। मैं सिर्फ अपनी चंद सबमिशन, जनाब ने फॉर एंड अगेंस्ट डिटेल
वेरी गुड, अच्छी बात है।
जी सर, डिटेल जनाब ने आर्गुमेंट सुन लिए।
आप हमेशा माशाल्लाह अच्छी तरह से आते हैं प्रिपेयर होके।
थैंक यू सर, थैंक यू। ऑब्लाइज सर। My lord, मेरी गुजारिश सिर्फ इतनी है।
represent PTI
as
a part.
आप इसके हक में
पाकिस्तान तहरीक इंसाफ। My lord, हमारी सबमिशन ये है कि माय लॉर्ड ने आइन की तशरीह करते हुए 62(1)(f) के बारे में फाइंडिंग्स दे दी। उसके बाद जो इलेक्शन एक्ट में अमेंडमेंट आई है, जो इन्होंने, जिसको हम ये समझते हैं कि although it is a person specific but without going into that issue, क्योंकि ये 62(1)(f) के मुतालिक ये इसको और जजमेंट को नलीफाई कर रहे हैं, इम्पैक्ट ऑफ जजमेंट को नलीफाई करने का जो तरीका कानून ने मुकर्रर किया है 232 सबसेक्शन 2 में, वो मुनासिब नहीं है, वो इनकॉन्सिक्वेंशियल होगी।
हम
ये
तो लेजिस्लेशन को देख ही नहीं रहे।
आप चैलेंज करें ना उसको, हम देखेंगे।
मैं इसके बारे में ये मैंने राय मांगी थी कि क्यों चैलेंज
समझे कि कोई ना कोई चैलेंज जरूर करेगा।
मैंने इसके बारे में वो इंस्ट्रक्शंस लिए कि ये चैलेंज क्यों नहीं हुआ एट दैट टाइम, ये अलग बात है। लेकिन मैं ये गुजारिश,
मटेरियल इंस्ट्रक्शंस आए नहीं।
वो मटेरियल इंस्ट्रक्शंस यहाँ हमारी वाली पार्टी में मेरी हद तक कभी होती नहीं है, तो इसलिए लेकिन
ये तो वो हम दरवाजा देखें, जहां तक वो बात है, आई डोंट नो, अगर गालिबन एक वो दरवाजा शायद हम उस पर हतमी कोई ना हो, वो बात आ सकती है कल परसों।
जी,
वो हम दरवाजे नहीं बंद करेंगे।
ठीक फरमा रहे हैं सर। तो मैं सिर्फ अगर 2-3 ये मैं इसको अगर पढ़ लूं, इस अमेंडमेंट को मैं लौट,
पहले आप ये बता दें इसके लाइफ के डिस्क्वालिफिकेशन के फेवर में या खिलाफ।
मैं ये कहता हूं कि इट शुड बी फॉर होल ऑफ द टाइम until and unless that constitutional amendment is made, क्योंकि 62(1)(f) के अंदर और 63 के अंदर डिफरेंस है। 63 ने सेल्फ इम्पोज रेस्ट्रिक्शंस कर दी हैं कि जब कोई शख्स 63G में या H में, फर्ज करो आइडियोलॉजी ऑफ पाकिस्तान या कंटेम्प्ट में सजा हो गया, उसके लिए 5 years कर दिया गया। अगर कोई शख्स 2 साल से जायद किसी भी मॉरल टर्पिट्यूड के मुकदमे में सजा में हो गया, उसकी सजा 5 साल कर दी गई, उसमें देयर इज नो डिस्प्यूट। यहाँ आइन बनाने वालों ने इसमें कोई टाइम फ्रेम नहीं रखा। मसलन चूंकि ये इंपॉर्टेंट क्वेश्चन है, एक शख्स पब्लिक ऑफिस होल्डर है, प्राइम मिनिस्टर है, वो मिनिस्टर है, कैबिनेट में बैठता है, बिलियंस ऑफ रुपीज, ट्रिलियंस ऑफ रुपीज के फैसले करता है। व्हेन सम कोर्ट ऑफ लॉ हैज डिक्लेयर्ड हिम एज ए करप्ट मैन, करप्शन प्रूव हो जाती है, खा वो 1 रुपए की हो या 1 बिलियन की हो वो प्रूव हो जाती है। और वो ये अलग बात है, उसके बारे में भी जनाब की जो गाइडलाइन आएगी, कॉम्पिटेंट कोर्ट ऑफ लॉ कौन सी होगी, सिविल कोर्ट होगी, क्रिमिनल कोर्ट होगी, फेडरल शरीयत कोर्ट होगी, या सुप्रीम कोर्ट ऑफ पाकिस्तान ने फाइंडिंग्स दे दी हैं। बट द इशू इज ये समवन इज,
देखिए मुगर मेरे लिए एक मसला ये खड़ा हो रहा है, आपका पार्टी मेंबर फैसल वावडा को तो रिलीफ मिली है और वो फॉलो नहीं हुआ है समीउल्लाह बलोच, ठीक है। अब कल को कोई आएगा कहेगा जी शोएब सानी के पास इख्तियार नहीं था पार्टी, क्योंकि आपने कोई चीज फाइल नहीं की हमारे सामने। आप अगर आईनी बात कोई करना चाहते हैं तो अपने ये आप नहीं कह सकते हैं मैं फलां को रिप्रेजेंट कर रहा हूँ, आप अपने आप को रिप्रेजेंट कर सकते हैं,
ठीक है सर।
आप किसी और
मेंबर ऑफ पीटीआई मैं अपने आप को
अपने किसी और को रिप्रेजेंट करने के लिए आपको पता है तरीकेकार होता है,
ठीक फरमाते हैं।
तो वो कल को कोई खुदा न खास्ते आप पे उंगली ना उठाए, हम सबसे चाहते हैं कि आप पे कोई उंगली ना उठाए।
ठीक फरमा,
अंडरटेकिंग भी दे सकते हैं ना
जी सर,
अंडरटेकिंग दे सकते हैं कि अभी थोड़ी देर बाद आप जमा कर।
जी मैं जमा करा दूंगा, अंडरटेकिंग दे सकते हैं।
वो मगर हमें आईनी बात बताए ना।
जी सर, मेरी जो सबमिशन है
अभी शायद ये इशू नहीं है, ड्यूरेशन वाली बात तो बाद में आएगी। पहले आप कैसे पढ़ते हैं कि ये डिक्लेरेशन कहाँ से आएगी? अभी झगड़ा इधर का है।
जी सर,
डिक्लेरेशन अपने लीगल सिस्टम जो हमारा है उसमें ऐसी डिक्लेरेशन कहाँ से आएगी?
जी सर, चूंकि 18th अमेंडमेंट में ये डिक्लेरेशन का लफ्ज डाला गया ना, उससे पहले ये लफ्ज
बिल्कुल सही, लेकिन लाएं कहाँ से?
जी उसके लिए अब तो ये जो सेक्शन 32 ने उसको ऐड किया, जो उसके अंदर फिर जो ऐड सबसेक्शन 32 किया, उसके अंदर भी उन्होंने ट्रिब्यूनल को भी उसमें ऐड कर दिया, ट्रिब्यूनल को भी उसमें ऐड कर दिया, ट्रिब्यूनल को ये 232 को मुलाज़ा फरमाया जो ओरिजिनल था।
तो हम आपको कह रहे हैं ना, हम 232 में नहीं जा रहे, हम आपसे पूछते हैं कि 62(1)(f) में डिक्लेरेशन कहाँ से आएगी, ये सवाल है।
पहले इसमें तो फिर कोर्ट ऑफ लॉ लिखा गया है, जब कोर्ट ऑफ लॉ डिक्लेयर्ड बाय लॉ कोई कोर्ट है, मसलन कोई भी सिविल कोर्ट है और क्रिमिनल कोर्ट है जिसको लॉ के जरिए कॉन्स्टिट्यूट हुई है, कोई भी कोर्ट ऑफ लॉ जैसे कॉन्स्टिट्यूशन में।
मिसाल दें कि कोर्ट ऑफ लॉ में ऐसी डिक्री मिल जाएगी, ऐसी डिक्लेरेशन मिल जाएगी कि आप अमीन नहीं है।
जैसे मैं अर्ज करता हूँ, किसी के खिलाफ करप्शन का मुकदमा हुआ, जैसे ये 2 दिन पहले एक केस था माइलॉर्ड के पास ऑनरेबल सुप्रीम कोर्ट में आया,
मुकदमा नहीं हो सकता। ये इस तरह है कि इंटर पार्टीज का कोई सेल डीड का झगड़ा आ गया, सेल डीड उन्होंने कहा फोर्ज्ड है, चलिए ये बात तय कर दी, इंटर पार्टीज के दिस सेल डीड इज फोर्ज्ड। ये पहले तो जजमेंट इन रेम नहीं है, दिस इज रिलेटेड टू द पार्टीज ओनली। इससे फिर अखज़ किया जा रहा है कि क्योंकि सेल डीड फोर्ज्ड है, ये आदमी ऑनेस्ट नहीं है। क्या ये करेक्ट तरीका है इस डिक्लेरेशन का?
मैं एक दूसरी मिसाल, जो बड़ी क्लियर मिसाल देता हूँ। एक शख्स के खिलाफ FIR कटी, पब्लिक ऑफिस होल्डर था।
आपने कहा अब ये सिविल सूट के अंदर सेक्शन 12(2) की एप्लीकेशन फाइल होती है, फ्रॉड, वो फर्ज की डिक्री सेटिस्फाइड हो गई कि हाँ जी ये तो फ्रॉड है और 12(2) के अंदर डिक्री सेटिस्फाइड हो गई। अब वो आदमी अगर इलेक्शन लड़ रहा हो और कोई जाके कहे कि मेरी 12(2) की एप्लीकेशन इस शख्स के खिलाफ अलाउ हुई भी है और डिक्री मेरी सेटिस्फाइड हो गई है, तो ये तो फ्रॉड हो गया, तो फिर तो गया वो।
उसकी ग्रेविटी जनाब देखेंगे कि वो किस हद तक है। लेकिन मेरी जो सबमिशंस, अपनी सबमिशंस है ना, मैं जो अर्ज करता हूँ कि एक शख्स पब्लिक ऑफिस होल्डर था, उसके खिलाफ 1 अरब रुपए की करप्शन का केस प्रूव हो गया, ही वाज कन्विक्टेड और 10 साल सजा हो गई, 7 साल सजा हो गई।
वैसे क्रिमिनल का तो मसला ही कोई नहीं, उसमें
नैब वाले खुद लिख देते हैं कि 10 साल तक आप नहीं कर सकते।
वो तो लिखे हुए ना, आप हमें बताएं सिविल डिक्लेरेशन ऐसी हो तो
सिविल डिक्लेरेशन में कैसे होगी? वो थोड़ा सा उसमें इबहम जरूर है, मैं अर्ज करता हूँ ना, इबहम है, इसमें कोई शक नहीं। लेकिन इस इबहम को भी ऑनरेबल सुप्रीम कोर्ट उसको फिल इन नहीं कर सकती। ये मैटर विद प्रपोजल एंड सजेशन जनाब पार्लियामेंट को भेज सकते हैं कि इस इबाम को दूर करें।
आपका मतलब ये हुआ कि समीउल्लाह में जो डिक्लेयर किया गया, डिटरमाइन किया गया, वो नहीं कर सकते थे, ये आप कहना चाहते हैं?
जी।
और दूसरी बात है डिक्लेरेशन, अगर आप सपोज आज हम आपको कहते हैं आप ये डिक्लेरेशन बनाए कि फला आदमी आज के बाद सादिक और अमीन नहीं रहा, ऐसी डिक्लेरेशन आएगी ना, इससे हटकर कोई डिक्लेरेशन होगी, उसकी बुनियाद पर डिस्क्वालिफिकेशन होगी या नहीं होगी?
नहीं सर, फिर तो देखिए ना सर, ये जो डिक्लेरेशन होगी ये किसी मुकदमे में होगी ना, ये तो नहीं हो सकता मैं आज चला जाऊं आकर के किसी सादे कौमी नहीं रहा. That declaration in REM cannot be made.
करप्ट प्रैक्टिसेस और करप्शन की जो बात है ना, तो नैब ऑर्डिनेंस जो है उसके अंदर स्पेसिफिकली सेक्शन 15 दिया गया है इस काम के लिए.
Misuse of authority.
डिस्क्वालिफिकेशन टू कंटेस्ट इलेक्शन और टू होल्ड पब्लिक ऑफिस. 10 साल का पीरियड है इसके.
जी देखिए ना, आपने इतना आपका वास्ट एक्सपीरियंस है, आपने कभी ऐसी कोई डिक्लेरेशन ली है?
नहीं ली.
अच्छा नहीं ली. तो अगर नहीं ली तो फिर कैसे लेने का तरीका कोई तरीका है?
नहीं, मैं ये कहता हूँ कि उसका तरीका ये हो कि जब किसी के खिलाफ कोई भी मुकदमा है और वो मुकदमे के जरिए एक शख्स साबित हो जाता है
कि उसने फ्रॉड
किया या कोई ऐसी डिसऑनेस्टी की जिसमें प्रूव हो,
अगर उसके साथ ये भी लिखा जाए कि इज नो मोर सादिक और अमीन,
जी
फिर तो कोई बात है. ये डिक्लेरेशन यहाँ कॉन्स्टिट्यूशन में लिखा है कि नेगेटिव डिक्लेरेशन
कॉन्ट्रेरी टू
साइड में तो फर्क है. 420 का मुकदमा हो जाएगा वो और बात है. सिविल साइड पे आप तो किसी ट्रांजैक्शन को सेटिसाइड करेंगे ना कि ये गलत है, ये डॉक्यूमेंट गलत है, 12(2) की.
लेकिन मैलॉर्ड उसमें भी तो देखें, अगर फर्ज करो ये साबित हो जाता है,
अगर होगा तो वो दोनों पार्टियों के बीच में वो जजमेंट है ना.
नहीं सर, उसमें भी मैलॉर्ड मैं गुजारिश करूँ, उसमें भी अगर ये साबित हो जाता है कि मसलन ट्रस्ट डीड जो है वो जाली बन गई, ठीक है, फोर्स बन गई, उसमें FIR कट जाएगी.
वो काटे तो फिर और बात है, फिर तो आ जाएगा 63 में. वो तो मसला नहीं है. मसला ये है कि अगर सिर्फ सिविल हद तक इतनी तक ही है कि ये इसकी ये गलत है, ये फोर्स जिसने डॉक्यूमेंट बनाया है, इस हद तक डिक्लेरेशन इज बिटवीन इंटर पार्टीज, इट इज नॉट इन रेम.
माय लॉर्ड
तो कैसे होगा ना, ये समझाए ना.
लेकिन माय लॉर्ड अगर इवन इफ
कैसे,
तो he will be liable for that.
क्या डिक्लेरेशन आई है?
क्या डिक्लेरेरेशन आई है?
मसलन ये डिक्लेरेशन इस हद तक आ गई है कि that document was prepared and used as a forged document by them, that person.
हाँ, डॉक्यूमेंट फोर्ज्ड है. अब इसका मतलब है कि वो ऑनेस्ट डिसऑनेस्ट ये लिखेगा जज कि वो आप ऑनेस्ट भी नहीं है.
ये लिखेगा नहीं, इन्फ्लुएंस तो उसी का वही ड्रा होगा ना.
शोएब साहिन साहब, मजहर साहब ने बड़ी अच्छी मिसाल दी. एक कानून 12(2) में स्पेसिफिकली कहता है फ्रॉड, लेकिन लफ्ज फ्रॉड आ गया, वो जजमेंट सेटिसाइड हो गई, ऑर्डर आ गया कोर्ट का, ठीक है. तो अब ये जो मिसाल है, पहली बात तो आपको पता है कि सिविल कोर्ट से डिस्ट्रिक्ट कोर्ट, फिर हाई कोर्ट, फिर सुप्रीम कोर्ट 15 साल भी लग सकते हैं, 10 साल भी लग सकते हैं. तो वो लाएगा ऑर्डर, वो तो सेटिसाइड हो जाएगा, वो गया, हो सकता है सुप्रीम कोर्ट ऑर्डर को सेटिसाइड कर दे. तो देखिए इतना सिंपल नहीं है. दूसरी बात ये है कि तो फिर आप उधर इस तरह हर तरह का मिसयूज शुरू हो जाएगा कि जी आपने ये सूट डिसमिस, दिस इज फ्रॉडुलेंट सूट वाज फाइल्ड. ऑब्जर्वेशन हम कभी दे देते हैं, कभी हम कॉस्ट भी लगा देते हैं, कभी फ्रॉडुलेंट सूट होते हैं हम उसमें ऑब्जर्वेशन नहीं देते हैं, ठीक है. तो ये उस हद तक होती है बात. इलेक्शन से इसका बात का ताल्लुक अगर हमने जोड़ दिया तो फिर तो फ्लड गेट्स ऑलरेडी खुल गए, मगर तो कोई हम कर ही नहीं सकेंगे कोई काम. हर कोई ना कोई आपका जजमेंट उठा लाएगा, आपके खिलाफ होगा. देखें इन्होंने शाहीन शोएब साहब इतने सीनियर वकील हैं, इनकी देखें पिटीशन डिसमिस हो गई. इसका मतलब वो वकील रिव्यू में आपको रिव्यू में लॉयर को सर्टिफिकेट देना होता है, ठीक है. देखिए उन्होंने झूठा सर्टिफिकेट दिया, तो ये तो कई बात आपको डिस्काउंट. अब यकीनन आपकी कोई रिव्यू पिटीशन अलाउ तो नहीं हुई,
आज तक नहीं देते हैं, आज तक नहीं हुई. हम कहते हैं
बहुत मुश्किल होता है.
हम वो सर्टिफिकेट देते हैं ये रिव्यू के लिए फिट है फॉर के रिव्यू की पिटीशन फाइल हो सके. ये नहीं होता कि हर हाल में हमारे हक में.
देखिए ये
आप कहते हैं दिस इज ए फिट केस फॉर रिव्यू, ये आप लिखते हैं
हमारी राय में,
जिनको रूल्स में लिखा हुआ है दिस इज ए फिट केस.
हम ये नहीं चाहते
तो कभी भी सर्टिफिकेट
हो जाए, कोई आप ये सुन रहा हो कि बड़ा अच्छा मौका मिल गया.
लेकिन मिसयूज ऑफ लॉ तो हमारे यहाँ कॉमन है ना लॉर्ड, इसमें तो कोई शक नहीं है. लेकिन जब हम इंटरप्रिटेशन की तरफ जाते हैं,
सुप्रीम कोर्ट पहुंचेगा ट्रेवल करते हुए, तो पता नहीं क्या बनेगा उसका. इलेक्शन भी हो जाएंगे, 3 इलेक्शन हो चुके होंगे.
अब दूसरी बात बता दे, चले मान लिया डिक्लेरेशन भी आ गई, लाइफ कैसे होगी जब कॉन्स्टिट्यूशन नहीं बता रहा?
तब वो इस तरह है.
देखिए आपने एक बात की कि 63 में बताया, उनको तो पता था कि 63 में टाइम दिया तो
नहीं दिया. उसके लिए जरूरी है ही इज ए सिटीजन ऑफ पाकिस्तान. मसलन सिटीजनशिप छोड़ देगा तो he will be out forever. यहाँ एक दफा सादिक व अमीन नहीं रहा तो उसका कोई क्राइटेरिया नहीं है कि दोबारा उसको ये साबित करे, वो खुद आकर के कहे अब मैं सादिक व अमीन हो गया हूँ। अब इसलिए यहाँ टाइम नहीं दिया लेजिस्लेचर ने और कॉन्स्टिट्यूशन मेकिंग अथॉरिटी ने, और इसलिए नहीं दिया।
हम क्यों प्रिज्यूम करें कि लाइफ
सोसाइटी ही मे बी सादिक एंड अमीन, एक पर्टिकुलर केस में अगर उसको कोई डेंट लग गया, मैं उस पर ट्रस्ट करती हूँ, आप उस पर ट्रस्ट, एंड टेस्टेड आदमी हो, तो एक केस में उसमें किस
उसका फिर क्राइटेरिया ऐसा होना चाहिए या कॉन्स्टिट्यूशन में या लॉ में कि अब वो बंदा ठीक हो गया है और उसके क्रेडेंशियल्स, उसका पूरा एरिया के लोग या उसकी कोई डिक्लेरेशन का कोई तरीका हो, फिर कोई लॉ में हो या
जब आप लाएंगे चैलेंज हम देखेंगे उसको। मेरे ख्याल में आज के लिए इन कंक्लूजन आई जस्ट वांटेड टू थैंक ऑल द काउंसिल. The amicus in particular, at very short notice, 2 of them came and one submitted a note. And at times, the conduct of all the council was excellent. Maybe there were some hard questions from our side, but these are no reflection on council. It is just to clarify our own thinking processes. So if we have overstepped, apologies in advance, and thank you for a very conducive hearing, everyone.
Thank you, my lord.
We will maybe we'll try to come up with a shorter order as soon as possible. Probably not today, but it will be very soon, inshallah.
Thank you.
Pray for us.